All right, so enforcement of foreign judgments we're going to learn about today. And why is this important? Um, well, if you have a judgment in one state or district or jurisdiction, it could be in the common law, it can be in a jurisdiction out of the United States. But if there's been any process that's been done that has adjudicated your dispute or matter at hand between two different entities, two different persons, two different people, corporations, individuals, what have you, um, you need to learn about how to enforce these judgments that that you're getting or that are being created. So I think that just by going through and reading this, you'll get a lot of learning. And then if you have more questions or more information, you can contact us on our website, understandcontractlaw.com. We do have some interesting feedback about common law judgments and how to get them enforced and recognized in U.S. courts or state courts or Canadian courts or Australian courts or what have you. So you may want to read this post on our website, but that's not the purpose of this video. The purpose of this video is to read what Google and Wikipedia have to say about foreign judgments. So here we go. Enforcement of foreign judgments. In law, the enforcement of foreign judgments is the recognition and enforcement in one jurisdiction of judgments registered in another jurisdiction, called a foreign jurisdiction, as opposed to domestic. Foreign judgments may be recognized based on bilateral or multilateral treaties or understandings, or unilaterally without an express international agreement. Okay? Definitions of terms. The, quote, recognition of a foreign judgment occurs when the court of one country or jurisdiction accepts a judicial decision made by the courts of another, quote, foreign country or jurisdiction, and issues a judgment in substantially identical terms without rehearing the substance of the original lawsuit. In American legal terminology, a foreign judgment means a judgment from another state in the United States or from a foreign country. To differentiate between the two, more precise terminology used is a foreign country judgment for judgments from another country, and a foreign sister state judgment from a different state within the United States. So that's like, Citibank sues you in sues your person in Ohio, and you beat them off, which is pretty easy to do if you put in the right pleadings and arguments or conditional acceptances or whatnot. But you beat them off with a lawsuit, and you have a final order in your favor. Well, Citibank can't just go and sue you in Pennsylvania, Virginia, Missouri, Texas, California, Oregon, Washington, Nevada. They can't just keep suing you, and certainly they can't sue you in the UK and Australia just because they want to. Once decided, always decided. Res judicata. Once decided, always decided. Or stare decisis. Okay, so, if you Google stare decisis, Latin for to stand by things decided. Stare decisis is essentially the doctrine of precedent. Courts cite the stare decisis when an issue has been previously brought to the court and a ruling already issued. Generally, courts will adhere to the previous ruling, though this is not universally true. In common legal systems, a precedent or authority is a principle or rule established in a previous legal case that is binding on or persuasive for a court or other tribunal when deciding subsequent cases with similar issues of fact. The general principle in common law legal systems is that similar cases should be decided so as to give similar and predictable outcomes, and the principle of precedent is the mechanism by which that goal is attained. Black's Law Dictionary defines precedent as a rule of law established for the first time by a court for a particular type of case and thereafter referred to in deciding similar cases. Common law precedent is a third kind of law on equal footing with statutory law and regulatory law. Stare decisis is a legal principle by which judges are obliged to respect the precedent established by prior decisions. The words originate from the phrasing of the principle in the Latin maxim stare decisis et non quite movere, to stand by decisions and not disturb the undisturbed. In a legal context, this is understood to mean that courts should generally abide by precedent and not disturb settled matters. In legal context, this is understood to mean that courts should generally abide by precedent and not disturb legal matters. And it's got a cool resource there. Case law is the set of existing rules which have been made new interpretations of law and therefore can be cited as precedent. In most countries, including most European countries, the term is applied to any set of rulings on law which is guided by previous rulings, for example, previous decisions of a government agency. That is, presidential case law can arise from either a judicial ruling or a ruling of an adjudication within an executive branch agency. Trials and hearings that do not result in written decisions of a court of record do not create precedent for future court decisions. And then there's a whole bunch of other stuff down here. There's two components, yada yada yada, yada yada yada. You can learn a lot about these principles by Googling, going to Wikipedia, so on and so forth. So that's stare decisis. Res judicata. Res judicata. Res judicata, or res injudicata, also known as claim preclusion, is the Latin term for a matter already judged, and may refer to two concepts. In both civil law and common law legal systems, a case in which there has been a final judgment and is no longer subject to appeal, and the legal doctrine meant to bar or preclude continued litigation of such cases between the same parties, which is different between the two legal systems. In this latter usage, the term is synonymous with preclusion. Collateral estoppel. In the case of res judicata, the matter cannot be raised again, either in the same court or in a different court. A court will use res judicata to deny reconsideration of a matter. Collateral estoppel. That's cool. Let's look that up. Known in modern terminology as issue preclusion, is a common law estoppel doctrine that prevents a person from relitigating an issue. One summary is that once a court has decided an issue of fact or law necessary to its judgment, that decision precludes relitigation on the issue in a suit on a different cause of action involving a party to the first case. The rationale behind the issue preclusion is the prevention of legal harassment and the prevention of abuse of judicial resources. So basically, you can't just keep suing someone over and over and over. Parties may be estopped from litigating determinations on issues made in prior actions. The determination may be an issue of fact or an issue of law. Preclusion requires that the issue decided was actually and necessarily decided as part of a valid final judgment. Valid final judgments of state courts are given preclusive effect in other state and federal courts under the full faith and credit clause of the U.S. Constitution. Valid final judgments must be issued by courts with appropriate personnel and subject matter jurisdiction, yada yada yada. I mean, this is all really good stuff to read again, read again, read again. Definition of terms. The recognition of a foreign judgment occurs, now we're back to enforcement of foreign judgments. The recognition of a foreign judgment occurs when the court of one country or jurisdiction accepts a judicial decision made by the courts of another foreign country or jurisdiction and issues a judgment in substantially identical terms without rehearing the substance of the original lawsuit. In American legal terminology, a foreign judgment means a judgment from another state in the United States or from a foreign country. To differentiate between the two, more precise terminology used is foreign country judgment and foreign sister state judgment. Okay, we went over that already. Once a foreign, so it could be from, the UK to Australia to Nigeria to the United States, or it can be within the United States. It's called foreign sister state judgment. New York, California. If you've got a divorce child support judgment or credit card judgment or anything that's been done, like I said, I gave the example in Ohio, you can go and register that judgment in New York or Florida if one of the parties has moved to that state and you need to garnish their wages in that state or put a lien on their assets in that state. You are going to need to register that foreign judgment in that state that you're chasing after the debtor and trying to enforce the judgment. So those are the two kinds right there. And an example that you're familiar with, like I said, is maybe child support. If you're trying to get the other party to pay their child support payments and they're being a debtor and hiding and not paying for it, you can register that judgment in the state that they moved to. If there has already been a divorce or child support judgment or alimony judgment or anything determining those payments. Same thing with, like I said, avoiding subsequent debt collector, credit card lawsuits, more things like that. It's clear to see how this relates to what many of you are already familiar with. You can't just number one, once it's decided in one jurisdiction, the other states within the United States will have to recognize it, and it's the same thing for foreign judgments. That's a foreign country judgment. So if the parties have crossed, international lines, and the one who initiates the lawsuit wants to open up the lawsuit in Great Britain, if they lose, they can't just go and open up the lawsuit in the United States or France or some other country and continue harassing someone with endless amounts of lawsuits. You get one chance to bring all the facts, all the law, cite all of it, and get your chance to have your day in court against the other party, and that's it. That's it. So this is a problem that many people are having, disputing debts, third-party debt collectors or other entities, is that some people believe that they're getting foreign judgments and they're still getting lawsuits from these companies. And so if you read about the foreign judgment process on our website, you can learn all about, from our point of view, where people are missing the mark and what sort of process might be more applicable to what you're trying to get at. If you're trying to prevent a company from suing you, you have to have a adjudication, a judicial determination. This is the website of a group called the International Commercial Court, and this is it says that it is the principal judicial organ of the Sovereign Freeman Commission and was established in December 2012 by the Charter of the Sovereign Freeman Commission. The seat of the Sovereign Freeman Commission is Grand Cayman in the Cayman Islands, a party to the Convention of the Recognition and Enforcement of Foreign Arbitral Awards. That might be something that we look up. Okay. Of the principal organs of the Sovereign Freeman Commission, the ICC's role is an alternative dispute resolution forum, has jurisdiction inter alia, among other things, to resolve commercial disputes through administrative proceedings, judicial determinations, arbitration, and mediation. Proceedings are executed, governed, and construed in accordance with the governing laws of the contract and common law, and guided but not bound by private international law, the Uniform Commercial Code, UNCITRAL, and Law Merchant. The ICC is a court of record composed of a tribunal of adjudicators, each elected for terms of office of 3 years by the Sovereign Freeman Commission. The ICC is an official registrar for the International Commercial Registry, which the International Commercial Registry is a place where electronic public records can be posted in cyberspace. So many times after a judgment or arbitration is completed, the standard protocol is to post the outcome of that judgment somewhere in the public forum. You will see judgments posted in newspapers after they are heard and decided. People post claims of right to certain plots of land and give what's called constructive notice by posting for 3 or 4 or 5 or 6 weeks in the newspaper in a row, a couple times a week, a notice that if I'm claiming this plot of land that's been abandoned, and if anybody has any, I can't find out who the owner is, but if anybody in this area believes that they have an interest in this property, here's my information, please contact me. And so that's called giving constructive notice, when you can't deliberately serve a party, or you do not know who the John Does are. You can't name them by their name. So these are some reasons why posting things in public record in newspapers, at county recorders' offices, are important on UCC 1, filing notices. The International Commercial Registry is yet another place where you can post public notices as well. I'm trying to find their website here. International Commercial Registry. .com. International Commercial Registry offers online recording and viewing of documents you desire to share with others. Users have the option of making their records public or private. Public documents are available for view by the general public. Private records can only be accessed via a private URL. Records are available 24 hours a day, 7 days a week. To submit documents to the International Commercial Registry, click here for recording instructions. Okay, and there's more information there. Official languages are English, Spanish, French, and Russian. Okay, so International Commercial Court, there is services, court rules that you can read, which are quite lengthy to go into in this video. They have their own appeals process. You can have a request for adjudication here. Mediation $1,500, arbitration $2,500, administrative process $600. And then if you heard about them through this video, you can select contract law and they might offer you a discount. So this is the information that would be filled out. The governing rule or laws: common law, commercial law, private, international law, law of merchant, and adjudication agreement. You find and agreed to this court rules, so on and so forth. So this is like an adjudication for if you're having problems with debt collectors, companies that you believe that you resolved and settled the dispute with them and they're still harassing you. You can take your matter of your administrative process to the International Commercial Court, and they are fair and good experts on, or they will appoint an expert on the matters at hand of commercial law, common law, and administrative process to review your matter and come up with a judgment or mediation or arbitration. Let's see what else they have to say. The International Commercial Court, as a court of record established under common law, provides an alternative dispute resolution forum for the adjudication of judicial administrative proceedings. Judicial proceedings. By the way, it's also meant to, if you have a foreclosure situation, for example, the public court system does not have jurisdiction unless parties have failed to resolve the matter privately. So the International Commercial Court is a private court. So you could argue that the Superior District Court of the state of California, in such and such county, Los Angeles County, whatever, lacks subject matter jurisdiction, or must allow or approve of a continuance for 90 days pending the outcome of the private administrative mediation or adjudication process. And that could buy you more time to mediate and resolve your dispute before you waste taxpayers' time and money going to court and having both parties hire lawyers and deal with some long drawn out foreclosure case or credit card lawsuit or other situation. So let's finish reading this. Judicial proceedings are actions in which both the parties to a commercial dispute have consented to the court taking evidence under oath and have granted to the court the authority to make inquiries and judicial terminations. Administrative proceedings are actions in which one or more parties to a commercial dispute petitions the court to witness an administrative process to make determinations based on specific agreed upon terms and conditions and the facts and evidence established by records. The ICC provides for the presentment of process and of records under seal as an independent service and for those currently engaged in proceedings with the court. Estate and Trust Administration, custodian of records, fees, presentments under seal. Okay, so forms, court rules, court forms, pleadings. So, here you go. There are documents where you can get a copy of the sample ICC summons. I believe this is old and they would be updating this. Let me get you a updated version. Let me pause this for a second. Okay, here is a current latest update sample. No, thank you. Okay. Of let's zoom out a little bit. Let's zoom in a little bit. Let's zoom in a little bit. Let's zoom in a little more for the purposes of the video. Of a summons. So the International Commercial Court process mimics any public court process. And like I said, let me just try to back up and close out. So if you read more about the enforcement of foreign judgments, when you Google enforcement of foreign judgments, you will learn that basically any judgment that provides due process from any court should be accepted in any other jurisdiction. As you can read here, between the foreign judgments may be recognized either unilaterally based on different principles of comity, i.e., mutual deference between courts in different counties. Between two different states in the United States, enforcement is generally required under the Full Faith and Credit Clause, Article 4, Section 1 of the U.S. Constitution, which compels a state to give another state's judgment an effect as if it were local. This usually requires some sort of abbreviated application on notice or docketing. Between one state in the United States and a foreign country, Canada, for example, the prevailing concept is comity. In law, comity is legal reciprocity, international relations. The principle that one jurisdiction will extend certain courtesies to other nations, particularly by recognizing the validity and effect of their executive, legislative, and judicial acts. The term refers to the idea that courts should not act in a way that demeans the jurisdiction laws or judicial decisions of another jurisdiction. Part of the presumption of comity is that other jurisdictions will reciprocate the courtesy shown to them. Many statutes relating to the enforcement of foreign judgments require that judgments of a particular jurisdiction will be recognized and enforced by a forum only to the extent that the other jurisdiction would recognize and enforce the judgments rendered by that forum. In the law of the United States, comity may refer to the Privileges and Immunities Clause, sometimes called the Comity Clause, in Article 4 of the United States Constitution. This clause provides that the citizens of each state shall be entitled to all privileges and immunities of citizens in several states, etc., etc. Australia and European countries, for instance, will not extradite a person to any country which has a death penalty if the person is charged with a crime that may lead to sentence of death, unless that country agrees to not enforce the death penalty. Judicially, comity should not be misinterpreted as implying that all laws are of universal jurisdiction. In many countries, comity is effective only to the extent that foreign laws or judgments do not directly conflict with the foreign country's public policy. For example, the United States will not enforce foreign judgments, such as defamation judgments, where the foreign court did not provide as much protection as the free speech protection in the United States. So, as you can see, they don't automatically decide, they don't automatically have to enforce a foreign country's judgment automatically if you sued somebody for defamation of character and won, a $20 million claim in the United States, and you wanted to enforce that and register that judgment in France because the company or person who you have a suit against is in France. France is not necessarily going to execute and have their local sheriffs collect or lien or levy the bank accounts or wages of or assets or foreclose on the property of that individual or company in France. When you're going after punitive damages, it's not going to be identically enforceable. It's been seen that the United States will reward dollar amounts way in excess of what other countries are comfortable with, aligning with as far as monetary judgments. So if you've been wronged by somebody, if you've been abused by a police officer and they broke your arm and you want to sue them for $1 billion, you can't just use the International Commercial Court to do a claim against someone who harmed you and then register it in the United States and think that you can get, the court to execute on that and then go and, levy the bank account and foreclose on that person's home, property, pension, retirement fund for $1 billion. I mean, that's not reasonable to expect that. You can't go after for monetary damages. It's not going to work like that. But where this principle of comity will apply when it comes to foreign judgments, creating collateral estoppel, is commercial affairs, negotiable instruments, commercial law, and protection against debt collectors and being harassed about matters that have already been decided. Okay, matters that have already been settled, debts that have already been paid or discharged. This is a perfect and the decision that comes out of a court such as the International Commercial Court should have no problem being recognized in the United States. The United States' public policy, as we mentioned, is an important element to this, is to protect people from, they have Fair Debt Collection Practices Act, the Fair Credit Reporting Act. So to protect its citizens and individuals from unfair credit reporting and unfair debt collection practices. So if you go to the Grand Cayman Islands and have some judgment that comes out of there through the International Commercial Court or elsewhere, through using a process and using these documents, will it be enforceable in the United States? Yes. Okay, and there's certain principles as well. There's certain, you have to give, I'm just going to go over right now the elements of enforceability of a foreign judgment in another country. So getting this judgment from Grand Cayman Islands through the International Commercial Court, or getting a judgment from any court in, France, Spain, some country in Africa, Asia, whatever, and then enforcing it within Canada, Australia, United States, and having success at getting that judgment enforced without having to go to a retrial and go to a recourt and do a whole, secondary decision. How do you have all the elements there where that court is going to recognize res judicata? Okay? And so giving due process and equal protection under the law is important. Let me find my list here. Having personal jurisdiction over the respondents. Providing proof that the respondent in the lawsuit was properly served. Allowing 20 days, minimal of 20 days of the lawsuit being served for the other party to respond. The court of competent jurisdiction having published rules of the court, and those published forms, like we mentioned, like we showed you where you can download the forms on the website. Okay? So that anybody will know the format and style of responding to any lawsuit. So that's fair for everybody. The court having a docket sheet. Okay? So, let me see if there's anything else. The court issuing an abstract of judgment. So, okay, and the ICC has a tribunal for appeals, and it has an appeal process, so that any judgment can be appealed and given a second look based on any errors or omissions. Oh, I was never properly served, I was never given the proper time to respond, etc., etc. So as you can see, there are many criteria that a judgment can be denied to be enforced in a foreign country. If you bring up the argument that, well, I was never properly served, I was never given at least 20 days, I was never given due process, there's no court rules, there's no court forms on the website, there's no published rules, there's no docket sheet, if you bring up these issues, then it is likely that you can get a judgment to be considered void, and a void judgment has no, legal force and effect. But we can look up void judgment. Judgment entered by a court is void if a court lacks jurisdiction over the parties or subject matter of the lawsuit. A void judgment may be entirely disregarded. A judgment is void on its face if the trial court exceeded its jurisdiction by granting relief that it had no power to grant. A void judgment is a judicial decision that was invalid and had no legal force and effect the moment it was issued. Something that is voidable may be avoided or declared void by one or more parties, but such an agreement is not void per se. Alright, so unless you can prove that it's a void judgment because it did not provide equal protection, due process under the law, or was in some way corrupted, or maybe the court officers had a conflict of interest in the case, those are the only way that a judgment coming out of one country would not be acceptable. Okay? So, read more about enforcement of foreign judgments. I can go on and on and on. I'm going to just try to touch on a few other things here. Here we go. Exercise of jurisdiction and recognition cases. In the country that issued the judgment and the country recognition sought are not parties to the Hague Convention on Foreign Judgments in Civil Commercial Matters, the Brussels regime, all European countries as well as Iceland, Norway, and Switzerland, or a similar treaty or convention providing for the route of registration, enforcement, and judgment between states, the courts of most states will accept jurisdiction to hear cases for the recognition and enforcement of judgments awarded by the courts of another state if the defendant or relevant assets are physically located within their territorial boundaries. Whether recognition will be given is determined by the lex fori, i.e. the domestic law of the court where recognition is sought, and the principles of comity. The following issues are considered. Whether the foreign court properly accepted personal jurisdiction over the defendant, whether the defendant was properly served with notice of the proceedings and given a reasonable opportunity to be heard, which raises general principles of natural justice as will frequently be judged by international standards. Hence, the rules for service of a non-resident defendant outside the jurisdiction must match general standards, and the fact that the first instance court's rules were followed will be irrelevant if the international view is that the local system is unjust. Whether the proceedings were tainted with fraud, and whether the judgment offends the public policy of local states. So as you can see, there's some very narrow ways that a foreign judgment would not be considered. There's a general reluctance to enforce foreign judgments in which involve multiple or punitive damages, like I mentioned. In this context, it is known that the U.S. is not a signatory to any treaty or convention, and there are no proposals for this position to change. When it comes to seeking the enforcement of U.S. judgments in foreign courts, many states are uncomfortable with the amount of money damages awarded by U.S. courts, which consistently exceed the compensation available in those states, like I mentioned before. Getting a U.S. judgment for $30 million when French court would only award $1 million, they're not going to just immediately enforce your judgment for multiple or punitive damages. However, to avoid you being liable for a debt, or to concur that your balance due on an account is zero and the debt collector needs to leave you alone, that is a completely different story, because it is within the public policy of the United States and all other major countries that people are dealing with. You can't be harassed by debt collectors. And if you've had an arbitration in the matter through the International Commercial Court Tribunal, and they've been given an opportunity for appeal, and they've been properly served, and you can provide proof of all this, there's no jurisdiction conferred in any other state, in any other country. Once decided, always decided. So, the International Commercial Court is an option for people who would like to have an arbitration, a private adjudication heard if you're being harassed by debt collectors, if they're not leaving you alone, if they're trying to collect on a debt that you believe has already been discharged, settled, is not legit, that they cannot provide proof that there is a debt, if they can't provide a wet ink signature, if they can't provide proof of accounting, transmission reports. There's all these ways that you can back them into a corner and ask them to prove that you opened an account with them, that there's still a balance due, all these different issues. And you can use the International Commercial Court for a lot of other issues as well. I'm just giving one, common example of what people are using and getting remedy and successes with at the moment. Further, the fact that the U.S. courts sometimes claim extraterritorial jurisdiction offends other states' conceptions of sovereignty. Consequently, it can be difficult to persuade some courts to enforce some U.S. judgments. The Hague Choice of Court Convention provides for the recognition of judgment given by the court chosen by the parties in civil and commercial cases in all other parties to the convention. I'm not going to read this whole thing. As you can see, on and on and on. When seeking enforcement of a judgment in or from a state that has not adopted the Uniform Act, the holder of the judgment files a suit known as a domestication action. Since the full faith and credit clause of the U.S. Constitution requires that states honor the judgments of other states, the domestication of a judgment from another state is generally a formality, even in the absence of the expedited procedure under Uniform Enforcement of Foreign Judgments Act. Interesting. Now, here's cool. A little detail. New York State and Connecticut are two of a small minority of U.S. jurisdictions that does not simply allow a judgment creditor to file a foreign judgment from a sister state if the judgment was obtained by default, meaning the other side never showed up to contest its entry into the other state by, for example, defending himself at trial. Or the judgment was obtained by confession, meaning the other side signed paperwork allowing judgment to be entered against him. Instead, a party wishing to domesticate the foreign default judgment or foreign judgment obtained by confession must bring another action in New York State, quote, on the judgment, where the relief sought is to have the foreign judgment domesticated in New York State. Moreover, a quicker motion action procedure is available in New York where the owner of a foreign judgment, default judgment, or judgment confession files a summons and notice of motion for summary judgment in lieu of complaint. So in New York and Connecticut, you can't just register a foreign judgment if you're a judgment creditor that you got in Pennsylvania, New Jersey, Florida, Ohio, Texas, Cayman Islands, Brazil, the UK, France, wherever. You would have to file a relatively quick motion and notice of motion for summary judgment in lieu of complaint. But in any other state, you can follow their rules for registering a foreign judgment, and you can Google registration of foreign judgment, Illinois. And you can find on Illinois' website rules and details and exact forms to register a foreign judgment there. And you can Google and find that by state just by using a search engine. Here's the rules, formal procedure, this, that, da-da-da, 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 da-da-da. And here you go. They give you the samples. Petition to revive judgment. Okay, I'm not sure that's looking for. Order for revival of judgment. Okay, not necessarily what we're looking for, but close enough. Filing a judgment entered in a different county in Illinois. And it's got the state statutes. The person in whose favor of a judgment is entered may have the judgment enforced by a proper officer of any county in the state against the lands and tenements, goods and chattels of the person against whom the judgment is entered, or against his or her body when the same is authorized by law. Upon the following of the office of the clerk in any circuit court in the county of the state, the transcript of judgment entered in any county in the state, enforcement may be had thereon in that county in the like manner as in the county where originally entered. Okay? So, there you go. If you register and file a foreign judgment from another county, from another state, they're telling you how to do it here in Illinois. The primary purpose of this procedure is to enforce the judgment against a debtor residing in a county outside the county where the judgment was originally entered, to enforce a judgment against real property located in the county. It is also used when a citation to discover assets must be filed in the sister county pursuant to State Court Rule 277. To enforce a judgment of a sister county, counsel must file in the circuit court of the new county a certified copy of the judgment entered in the original county. And the International Commercial Court does issue certified copies of their judgment. You can request that, you can pay for it, they will mail it to you, and you can put that certified copy in the local county. No further notice of hearing is required or necessary. Isn't that cool? No further notice of hearing is required or necessary. So you do not need to have a hearing. Just read this and file it and register it properly. Now, here is that notice of entry. After you get a judgment from the International Commercial Court, let's read actually the summons. I know I'm just plowing through this over and over and over. The summons, an International Adjudicatory Act. So this is summonsing. Okay, Smith Family Trust is the claimant, and J.P. Morgan Chase Bank is the respondent. So an example would be Smith Family Trust is probably defending or going on the offense to stop J.P. Morgan Chase from harassing someone about a mortgage or credit card or some debt that has already been paid or discharged in some other way. Okay, so what that's probably an example of what this suit might be about. So we're summoning J.P. Morgan Chase to appear and defend themselves before we hear both sides and ask the International Commercial Court to be the, all extensive purposes, the judge and jury, and issue a decision through one of their adjudicators or a series of their adjudicators, looking at all the facts of the paperwork that's been submitted, all the records and evidence that have been submitted. So the summons would say something like this: and an international adjudicatory action has been filed against you in the International Commercial Court. You have 20 days after this summons is served on you to file a written response to the attached petition with the Secretariat of this court at the address given below. A phone call will not protect you. Your written response, including the case number given above and the names of the parties must be filed if you want this court to hear your side of the case. If you do not file your response on time, you may lose the case, and your rights, titles, and interests may be affected without further warning from this court. The rules for this court are available online at such and such link. If you file a written response, you must attach an affidavit stating when, how, and on whom, including addresses, you serve the response. Mail or deliver your response so that it is received by the Secretariat of this court at least 2 business days before the hearing. To the respondents, J.P. Morgan Chase Bank N.A., Office of the Chief Financial Officer, care of Marianne Lake, Chief Financial Officer, so-and-so address. So that's an example of what the summons might look like, which you're going to include with a copy of your complaint, your demand for performance, basically stop harassing me, clean up my credit report, stop your foreclosure action, and get the heck out of my life. And you're going to be including, you're going to be putting your pleading with the court, including, an introduction, statements of facts, legal analysis, relief sought, and execution. And in another video, we can go over a sample complaint in a situation against a debt collector like this. But first, we're going to go over, after all the process has been done and you've got your judgment, and there's quite a bit of processes I'm skipping over right now. Notice of entry is another example with J.P. Morgan Chase. Please take notice that the enclosed herein and incorporated herein by this reference is a true copy of a decision and order duly entered in the office of the Secretariat of the International Commercial Court on 3 March 2014. Please take further notice that pursuant to Article 25 of the Statutes of the International Commercial Court, within 30 days of receipt of any judgment, any party may notify the court of an intention to appeal to the Appellate Review Board, constituted in the same manner as the initial tribunal. The Appeal Tribunal shall be entitled to adopt the initial judgment as its own, modify the initial judgment, or substitute its own judgment for the initial judgment. The Appeal Tribunal shall not modify or replace the initial judgment except for clear errors of law or because of clear and convincing factual errors. The judgment of the Appeal Tribunal shall be final and binding, and judgment may be entered by a court having jurisdiction thereof. Any party may notify the court of an intention to appeal to the Appellate Review Board to the International Commercial Court by addressing said appeals to Appellate Review Board, International Commercial Court, care of General Post Office Box, blah blah blah, dated, signed by the claimant. So the claimant initiating this lawsuit would sign that, mail that to the party, along with a copy of the judgment, and serve it upon the respondents, J.P. Morgan Chase & Co., and have an affidavit of service, and that would be sufficing with the rules of being able to register your foreign judgment. Okay, so going back to here, if you Google registration of foreign judgment, Texas, Tennessee, California, you're going to find some websites that come up that give you, clear instructions on what to do. And different things to consider based on, whatever state. Now, registration of foreign judgment, in federal court, is probably a really better action than doing it on a state-by-state level. Registration of foreign judgment, cross state lines, U.S. Code 28 U.S.C. subsection 2467, enforcement of foreign judgment. Thanks. Quite some interesting things to read to really understand these processes. So, if you contact the Understand Contract Law and uwin.com, this is another matter. Maybe we'll save this for another video. This video is getting kind of long. Hague Convention on Foreign Judgments in Civil and Commercial Matters. So read that. Read the Uniform Enforcement of Foreign Judgments Act. And it'll give you all the criteria for making sure that your foreign judgment can be registered, recognized, and acknowledged. Anyone is free to go to the internationalcommercialcourt.org, contact us, request for a case manager, use this form to request an adjudication agreement and request for adjudication. You can read our website about foreign judgment registration. You can contact us for assistance, guidance, case managers, hiring secretarial data entry people to assist you with getting your paperwork in order, provided that it is not entailing any legal advice. But read this post here. Go to understandcontractlawinewin.com, free education, hover the mouse over free education, and there's a bunch of different things you can click on, which are always being updated. And if you click foreign judgment registration, you will get a nice overview here of why people are having trouble and still getting harassed by debt collectors, still getting lawsuits, is because they don't have a proper foreign judgment. They may have, they may think they have the bank in default and have their consent through tacit acquiescence to get the bank to leave them alone and have a zero balance, but it's not good enough in many cases. In many cases, it is good enough. It just depends on what you're trying to do. But here is an overview of the foreign judgment process flowchart. Summons, which is the document we showed you, plus a notice of settlement offer, perhaps request regarding a statement of account showing a zero balance with an affidavit of service, and this just goes through a whole flowchart. You may, with no response, be issuing a petition for default judgment and issuance of a certificate of claim, affidavit in support of undisputed material facts, and a proposed default judgment order. And with no response in 10 days, you may get the court issuing a default judgment and a certificate of claim and an abstract of foreign judgment. And then this goes through the whole flowchart of registering the judgment, like I stated. Select the court for enforcement. Google, federal, how to register foreign judgment. Federal court, how to register foreign judgment in New York, New Jersey, California, whatever, and then how to go and enforce judgment. So, comprehensive process. I know I'm speaking really, really fast. I'm just trying to pack the information into here. And if you look at this flow chart, or go over with a coach, to learn about this process, so you could perhaps use it as a plan of action for yourself, or otherwise, you want to know what will happen if there is a response, and how to do proper conditional acceptance or rebuttal on a point-by-point basis, request for telephonic hearing, and then a petition for declaratory judgment as opposed to a petition for default judgment. So, the court has a right to deny your default judgment or deny your declaratory judgment if you did not issue your pleadings properly, and you want to make sure that you don't waste your time and $600 opening up a case and not getting anywhere. So we recommend calling the UCL hotline, getting some assistance, getting some guidance, and learning about this process. If you're going to take more than a few minutes to speak with us, highly suggest you pay for a consultation, either in Bitcoin or with a credit or debit card through PayPal. You do not need to have PayPal in order to pay for a consultation using PayPal. You just need any debit or credit card, or you can mail a check or money order, or you can pay in Bitcoin. So it's very easy to get a consultation. We take any forms of payment, and that'll help. That's probably the first step to getting you on track with people that have a lot of experience with the foreign judgment process or with the private administrative process. And at least, even if you are going to try to do it on your own for the first time, at least getting some guidance, learning about the system, getting all the documents in order, and maybe if you have additional resources and elsewhere, you may want to hook up with someone to walk you through for several months or several weeks, everything you need to to get a foreign judgment. So, anyways, that's the end of the video. Look up some of these definitions, put them on flashcards, learn, study, get with somebody as a mentor, as a coach, whether it's us or someone else. But we tend to think and present ourselves like we know what we're doing more than many people. So if you would like to get with us and get some guidance, assistance, whatnot, we welcome that, and we do thank you for your support. So that's the end of the video. I hope that you guys learned something about getting foreign judgments, learning about how they will or won't work, res judicata, and getting debt collectors or other people off your back, and so forth. So I'm sure that there will be follow-up videos going into much more detail, but this is like a first introductory overview. And like I said, we do have conference calls as well. If you sign up for our private membership, if you sign up for our announcement list here and our private membership list down here, then you will be kept in the loop. And there are many free conference calls, although we're kind of phasing out the free conference calls to work with our individual clients, but there are several free conference calls happening in the spring and summer of 2014. So whenever you're watching this video, you might still be able to ask a whole bunch of free questions and listen to other people's questions that might ask things that you haven't thought about asking, so you can get more aware of what's going on, what successes people are having, and so forth. So thank you for watching.